How you doing? You're welcome. I mean, how many? Okay. People, on behalf of Mr. Jeffrey Williams, Mr. Adams and I would like the court to reconsider its denial on two previous occasions of bail. We filed this motion on April 24th, 2023, and we allege that Mr. Williams has been in custody since May 9, 2022. It's the date of his arrest. As the court previously heard, and if you need me to go over it, I will, but I'm assuming that this honorable court remembers the previous bond hearings and all the witnesses and exhibits that we placed before the court.
I do, sir.
I assumed you did. Mr. Williams, as you know and remember, did not flee when law enforcement officers came to his home on May 9th, 2022. He came out of his house. He called me, actually, and then came out of his house and was not in any way anything but compliant. It's now been more than 14 months so far. As the court may know and remember, the only potential nutritional foods consumed by Mr. Williams since May 9, 2022 include carrots, rice, lettuce, beans, and hot dogs. He mostly consumes products which have absolutely no nutritional benefits, which are M&Ms, chips, other processed or artificial bagged chemical substances. The lights, as the court may remember, in the small, isolated, solitary cell that Mr. Williams is housed in an off-site county, the lights are always on. They are brighter than the lights in this courtroom. So sleeping with bright lights in his face all the time, if he can get to sleep, and that is a form of torture which is not compatible with necessary restoration, sleep, restorative sleep required for Mr. Williams, who is a person on trial and needs to assist his counsel. Your Honor, this lifestyle for the past 14 plus months has caused physical harm to Mr. Williams. As the court recalls, he was taken to the hospital. If the court does not know, and Mr. Williams gave me permission, it is for his kidneys. Mr. Williams was raised in total poverty. He is used to not seeking medical help because he could not afford saying when he was injured or hurt. But he comes in this courtroom every day, writhing from pain from his kidneys. The kidneys removes the waste and extra water from the blood, evacuates through the body, through urine to maintain balances of the body's substantive fluids, to keep proper balance and levels of potassium, calcium, and sodium. The diet consumed by Mr. Williams endangers his health. Pretrial incarceration, Your Honor, is not supposed to damage a person's mind, spirit, or body. It is not for punishment. And this physical incarceration for such a long period of time, and the trial is estimated to last 6 to 9 months, and that's a considerable amount of time. The court has always said, I will put you on trial right away. I'm very aware that I denied bond to your client, and we appreciate that. We filed demand for speedy trial statutorily and constitutionally. But it is still a long time. As the court may notice, takes note of Mr. Williams, he has gained tremendous weight. If he's weighed now compared to the time he weighed on May 9th, you will see how much weight he has gained. He does not fit into his clothing anymore. He has all new clothing, and this is a problem caused by the kidneys and the lack of nutrition and exercise. Your Honor, the support for the community is still here with Mr. Williams. It remains here, as I previously showed this honorable court, to a packed courtroom. There are people who have not wavered at all. His family is all from this area. They love him, devoted to him. I speak with them weekly, if not more. His friends have stayed with him. Co-workers of Mr. Williams in the music industry. One is a gentleman who is on your screen in courtroom 8H, as in happy. His name is Jeff, which is Geoff, Ogunlesi, Ogunlesi. He has flown across our country to be here today when he found out that the honorable court set the hearing on Tuesday. He is in, if you need him, he is in courtroom 8H, and he will speak to the court if needed. There are professionals of the highest, officers of publicly traded company, the record label, that are on your Zoom. Mr. Kevin Liles, Liles, and he authorized me to tell you that he again embraced in total his previous sworn live testimony before this honorable court, and he stands by it with all of his power and might, and is willing to answer any of your questions that you would have of the prosecution for bond for Mr. Williams. Within this past month, Your Honor, Mr. Williams released a record. It was
Your Honor, I'm going to object to this proffer opening, or this portion of it is irrelevant to.
What is this lawyer talking about, man?
I
know
I
Young
can answer that
Thug
if I
probably.
need
All
to.
right.
It goes to his employment and his steadiness,
Okay.
employment in the industry, and in this trial at this
What is
time.
he
He has
talking
still
about?
maintained total employment, and he's still active.
Okay, all right, I'll allow it.
He is the number, that record, Your Honor, became the #1 rap record in,
Objection, Your Honor, if I may finish my objection to as to.
What's the basis? Relevance? I'm gonna overrule the objection
Thank you.
this time. All right,
is the #1 rap record.
let's move on, Mr. Steele. I understand it. You've convinced me that he's employable. So,
Well, I think the court should know it's also #2 record in any field. And I think that that's important.
The judge
for the
don't
court
like
to
this,
realize
bro.
there's no risk of violating condition of bond. This gentleman is an accomplished
Hell yeah, fuck that.
superstar in music. And I think that should weigh heavily that he would not jeopardize that by violating any condition of bond. Your Honor, America's justice system is built on the presumption that bail should be granted if there are any conditions that can be factored to ensure that the community is safe, the person does not pose a danger to the community, witnesses will not be intimidated, there'll be no obstruction of justice, the person will not, in this case, Mr. Williams, will not commit a felony or any crime, it says felony, but any crime
You
allowed
did a
bond,
bad job.
and that Mr. Williams will appear in court. Because if we do it the other way and maintain people and house people and warehouse them as Mr. Williams has been, then the presumption of innocence, which is our entire standard in Georgia, is gone because he's being presumed to be guilty. Your Honor, Georgia, unlike some states, for purposes of pretrial bond, the presumption of innocence remains with Mr. Williams accused of any offense, even a capital offense, which Mr. Williams is not charged with a capital offense, from arrest and even during trial. That's Vanderford, Vanderford versus Brand, Brand. It's 126 Georgia, 67 and 70, 1906. That means, Your Honor, that prior to trial, this honorable court must view Mr. Williams to be innocent.
I do. We don't look. I understand that you're trying to meet your burden in the sense of for the 4 factors under law. So I'm going to assume that I take into account the prior testimony that you've given in this particular case. Is there anything that you want other than the updated issues as to his record release recently? And employability. Is there anything else you want to augment that with?
Yes.
And then I'll let the state respond and present anything they may have to the contrary.
Yes.
Okay.
I have seen, and I've been here for every bond hearing except one, Mr. Miles Farley. I was not present for that. I've seen this honorable court deny every person's bond who's in this indictment. But then 7 months later, approximately, I saw the state who called all these people that they are a danger to community. They cannot fashion this honorable court cannot fashion any conditions of bond that would permit bond to be granted. And then 7 months later, the prosecution for 8 co-indictees offered, and this court accepted, negotiated pleas of time served. I can't wrap that around my mind.
What does that have to do with your case and your bond? I mean, each individual defendant is on his or her, in this case, their own merit. So why does that have anything to do with you?
Because I don't believe that the
Your client, I should say.
It's fine with saying me, but I don't believe that the proffers you're getting from the state are accurate. They have been proven to be inaccurate. I heard Mr.
Unfortunately, that's the way the law goes at this point in time, and our legislature hasn't addressed that. I mean, you've asked me to take a look at that. It's a different standard, pre-trial as opposed to when we're in trial. So, I mean, I understand that. I know you'll probably review that at some point in time, but at this point, I'm stuck with what I'm stuck with in terms of the legal posture of what the Constitution and the case law allows me to do.
There is no case that says that there's a difference between pre-trial and in-trial. That is not accurate.
In terms of the standard for motions and requirement for witnesses and live witnesses, should there be?
I misunderstood. I thought you were talking about bond law.
No.
Okay.
No, sir.
But you did grant bond. I was not present, but you did grant bond for Mr. Miles Farley. And there has to be a way that
On the individual circumstances of Mr. Farley, Mr. Williams I have to judge it on his particular circumstances.
I'm judging on Mr. Williams. I think Mr. Williams is more than bond eligible. Your Honor, we still have the same officers willing to supervise and surround a home that will have no electronics and no visitors. There will be no computer, no cell phone, and law enforcement officers outside of the house. We will pay for transportation to and from the courthouse. Otherwise, with an ankle monitor on his person, he does not leave that home. Mr. Adams and I and our other co-workers would request to meet with Mr. Williams inside that home on weekends and at nights. But other than us, nobody comes in. We can leave our electronics outside and bring paper copies because that's what I do at the outside jail anyway with Mr. Williams. Now, sometimes they do let me come in with my iPad to share discovery with Mr. Williams. I have to ask special permission, and I can do that through the court. But Your Honor, that is a factor that should be considered by the honorable court, that Mr. Williams can live at a location that can be vetted by the honorable court and law enforcement and the district attorney's office. I've gone further, not only with local police officers. If you don't like local police officers, I'm not saying anything wrong, but for whatever reason, that is not sufficient. There is a former Secret Service agent, there is a former U.S. Marshal that would take the responsibility of securing and transporting Mr. Williams in a home by himself and following every condition of bond, which we would ask for at this point, no visitors except legal, and not to leave the house, except that you had to go to a hospital and on an ankle monitor. Your Honor, liberty is the norm in our community. And this custodial detention prior to trial, when there are conditions that can be fashioned, is against our law. I will answer any of your questions. Mr. Ogunlesi will answer your questions, but he is Mr. Williams' manager. He will answer any questions, but he is behind Mr. Williams 100%, and Mr. Kevin Lyles is with the record label, and he also is with Mr. Williams, and I said I incorporate his prior testimony. Your Honor, I want to answer your questions. I want to thank you always, but this is a big case with a lot of discovery. We got discovery yesterday evening. I go through with Mr. Williams. I'm with him every day. I'm in court with him. I'm on a Zoom call with him, privileged Zoom call at the jail, or I'm with him at the jail. It is a lot better for us if he can stay awake, if he can participate and assist. And there are conditions that we have because he has the resources. That doesn't mean a resource to flee, like you heard, he can rent a plane. He's not doing that, Your Honor. He has too much to lose and he's too recognizable. Thank you, sir.
Okay. Thank you, Mr. Steele. All right. Ms. Love or Ms. Hilton, ladies.
Thank you, Your Honor. Your Honor, to begin with, I noticed that Mr. Steele referenced this status, the state that we're in, as pretrial. I noticed that and noted it because I wanted to make certain that the record is clear that we are currently in trial. We are not at a pretrial status or state. Mr. Steele referenced the fact that he has demanded a constitutional and a statutory speedy trial. And Mr. Steele also referenced the fact that the court promised or guaranteed that his client would receive one. And in fact, the court has upheld that promise and we are in trial. The statutes in the case law that reference bail and bond also use pretrial release interchangeably with bail and bond. And so I just wanted to point out that we are currently in trial. Also, Your Honor, since the time that this court first found that the defendant poses a risk of committing additional felonies and poses a flight risk, there has been no change in circumstances beyond what Mr. Steele has described as the defendant's discomfort, his dissatisfaction with the food that he is given, his choice to only eat certain foods that are provided, and that's it. Using the rationale that Mr. Steele employs, it's tantamount to being unconstitutional to confine anyone, given the description that he has made of his client's
You might as well let
circumstances.
everybody out. That's the
and
lawyer who did a bad job.
his assertion that every person should have the right to be free from those type of circumstances. I want the court to take note of the fact that the legislature, in enacting the statute for which Mr. Williams is charged, said that they wanted to make certain that the community is free of intimidation and threats caused by criminal street gangs, understanding that the state has the burden of proving all of the charges alleged in the indictment at trial.
This was holding them back, right?
We are at a position, however, where we can point to circumstances that reflect that the defendant poses a significant risk of committing additional felonies. These acts that the defendant has committed go very far back. They include acts of intimidation during the time that his brother, Your Honor, I am proffering as an officer of the court.
Yeah, let her finish, please, Mr. Steele.
I apologize for opposing objection.
Well, what's the basis?
It goes against the law for presumption of innocence. This is the charges in the indictment which the court has to presume innocence. It's an improper argument.
I believe it's just her proffer. I understand the legal requirement, and your client is presumed innocent. But I think Ms. Love is proffering how Mr. Williams is or continues to be a danger to the community.
Thank you, Your Honor.
Using the irrelevant information, it's the indictment. That's what Ms. Love is referring to.
It is not.
I don't think she's referring to the indictment. I think she's referring to acts that she claims will support the issues of bond. Bond is different from trial on the merits.
I understand, but I listened intently, and this is the indictment, and that's what Ms. Love just stated.
It's the charging document, but I understand, Mr. Steele, that it's different. The state has the burden. Bond is different than proof at trial. I understand that. Do you have any further objections, sir?
401 and 402, relevance is relevant what she said.
I'm going to overrule the objection. Go ahead, madam.
Thank you, Judge. The defendant, as far back as the time when his brother, Mr. Greer, who was before the court earlier this year, was initially set to be on trial, was one of the witnesses, and in fact, a person very close to the defendant, called the police and indicated that the defendant had messaged her, snitch hoes get murked, them and their kids.
Is this Mr. Williams you're referring to?
It is.
No. I did not get that.
Snitch hoes get what?
Murked, M-U-R-K-E-D.
Get murked and what else?
Murked, them and their kids.
Okay, I got it.
Your Honor, in 2015, Mr. Steele may present the objection that this is part of the indictment, but I can play the actual video where the defendant proclaims, so people lie to their mama, lie to their sister, lie to their children, and then want to get in court and tell the God's honest truth. You need to be killed, bro. That's from me and YSL. Those were his words. Judge, the intimidation factor and the risk of committing additional felonies that the defendant presents is not small. I know that you have heard proffers from prior prosecutors and you've heard evidence in previous bail hearings regarding witnesses' representations as it relates to this defendant. I can state, having experienced them myself, that the witnesses have expressed extreme reluctance. One said, with fear in his voice, he's different now. He's not the same. He moves like a man with millions of dollars behind his name. And in fact, the circumstances presented to you by Mr. Steele in both this hearing and in previous hearings reflect a similar sentiment. He moves like a man with $1 million behind his name. His hands won't get dirty, but people will enact his wishes. Since the time that we have been in this trial, we have seen it was captured on surveillance footage from inside this courtroom. One defendant who was on trial with this defendant bring to Mr. Williams Percocet in open court. Since the time that this trial has begun, we have had no less than 20 incidents, involving various crimes from drugs, shanks, and attacks being committed while the people who have been charged in this indictment are in fact confined. We have recordings of persons who are charged with Mr. Williams reaching out to other parties on the indictment, requesting permission from Mr. Williams to do harm to an opposition member who is in jail with the calling party. We have calls that are recorded of persons reaching out to Mr. Williams and conveying Mr. Williams's phone number and telling the called party, save this number under my name, just in case, the police get the phone. Everyone inside and who is associated with YSL knows who they need to keep the hands clean for, because Mr. Williams is the money that attracts the action and the willingness to act. When the shooting occurred that is referenced in the indictment of the bus for which Jimmy Winfrey was later convicted, it occurred at the same time that Mr. Williams was on stage in the other artist's hometown getting a not so receptive reaction from the audience. Your Honor, in 2015, of course, the court is aware that state alleges
Y'all let me know
Mr.
what y'all
Donovan
think. I gotta
Thomas
make some
was
business
killed as a
calls,
result
no
of
bond for Young Thugger.
conflict with opposition members, and that